all. That is not the allegation at all. I will explain everything, Malad. Either tomorrow or somebody.
No, you complete. We'll meet after 2 weeks. You complete a further investigation and submit a report to us in a sealed cover.
My lords, may give me 3 weeks. I'll.
And then we'll have to go out, we'll modify that.
Then my lords, 2 weeks. My lords, I'll tell them to complete the
No,
investigation.
we'll modify it. It has to be. You can't get away from doing something in America
No, my
or,
lords.
or Singapore or whatever it is. Mr. Nagmut, let me be very clear about it. Just because these are all ways and means of defrauding. Yes. Heard, Mr.
Yes. I cannot argue the matter.
Heard counsel, heard list Mr. Siddharth Arwal and senior counsel for the petitioner. Full stop. Arguments could not be concluded. Full stop. Paragraph. Learned counsel for the state of Tamil Nadu submit that the investigating agency stroke investigating officer shall conduct further investigation with regard to all the documents, material documents which may be relevant in the, all the material documents which may be relevant in the present case, and a report be submitted to the court within 3 weeks
Much obliged.
in a sealed cover.
But my compulsion.
Yes. You want to submit, then I write, you said I didn't submit, I did not take your name. If you submit even one, if you say, my lord, it will be heard, Mr. Nagmutul and senior counsel also. You said I stopped. I was going to write, you didn't make me write. Yes. Choice is yours. Yeah.
We enjoy this.
Yes. Choice is yours. Writing it doesn't matter. One more line for my secretary doesn't matter.
But one word has got its own.
Yes. Yes.
Right. So therefore, we are very cautious.
That is how you justify. You only stand up and say, my lord, and you justify it. So, it is good for both sides.
I wanted to say what, I got no disagreement with this order. What I wanted to say was,
Yes.
but they have to hold inquiry into the genuineness of these documents, not investigation.
No, investigation. Investigation with regard to all documents which he may produce. You produce if you have anything else also. We'll take it to the ultimate conclusion. No getting away with this technicalities in the law with regard to these. White collar.
Did not file anything
No,
before High Court.
my lords, these additional documents were not filed by the prosecution.
Why matter is related to the year 2017.
My lords, I understand that.
And the statement of materials to be placed before the authorities 2021. Till 25, no materials available. Suddenly, how materials will be before you?
My lords, now that they have provided the same, my lords, we'll also do an independent investigation.
Then
And my lords, we will conduct whether both on the genuineness and on the investigation with respect to the transaction, then we'll do an
Then
analysis.
how to find fault with the order passed by the High Court?
My lords, that's why the supplementary charge sheet would be filed, my lords, and then both the charge sheets would be taken together.
How can you find fault with the order passed by the High Court?
My lords, that's why my request was that if my lords would direct,
If
let
they
us complete
find-
the investigation
Then
in
we
3
may
weeks.
mold then if we
Let us
find
complete-
material, that is why we say, give it to us in the sealed cover.
Yes, my lords, we'll give it to my lords.
If we find, then otherwise,
I can only say this, Malad. That is over. I'm not connecting anything.
everything is over now.
Submission.
Everything is over
25
now.
transactions where the subject matter of the investigation, all the 5 were explained. They were not able to produce any document, whereas we produced documents based upon which, the court said, our document was produced to the police also. Court said that regarding these 5 transactions, there is no criminality. Therefore, the court was pleased to quash. Now, they are creating a new story.
No, Mr. Nagmuthu, we are appreciating that. We are very conscious of that. But ultimately, truth has to prevail, justice has to be done. So we may modify, we may clarify the situation. You are right. This, as has been observed by brother, we will see what the High Court has done. That is another thing. But in the larger interest for dispensing
In the larger interest,
substantial justice between the parties, we have to take a holistic view. For that, we are getting a report for our consumption in a sealed cover. Everything not interfering with the High Court order will not save you.
What I submit.
So we are basically at what is required to be done in the facts and circumstances of the case.
The facts and circumstances, Murad, they cannot develop a new case now altogether and say, referring to some other transaction. Murad, it was never investigated, it was never subject matter of the case at all.
That's why,
Only 5, please wait, sir.
that's why Lordship
Please
asks for that
please
inquiry.
wait. Let me complete. There are only 5 plus 5, 10 transactions which are the subject matters of the investigation. That is it. All the 5 were explained. Murad, court found that there is no criminality in respect of these 10 transactions. Over. Now, Murad, they are bringing in some more things which are not the allegations at all in the FIR or during investigation. After several years, now they are.
Allegation is misappropriation.
My lord,
Litigation is misappropriation.
misappropriation in,
And he is now able to place before this court at least one particular check of 10,000 Singapore dollars. Transfer into your own account or into your father's
yeah,
account.
yeah.
That
My lord,
proves
this
the
document, my lord, this.
Diversion, fraudulent diversion. You have
This
no authority to
document-
give it to your father.
May I kindly cut that? This document has been produced only on 27th. It was produced. But I don't, how many years before the transaction took place? I want to take instruction on that.
You are right. That is why we are, you also take it. In the meantime, let counsel for the respondent number. You are for the which respondent?
Respondent, private.
Respondent is also, it shall be open to the counsel for the Mr. Nagmuthu to file any response to the pleadings of the petition.
Additional document, additional document.
To the, all, everything is we kept open. Give you a free hand.
Much obliged, my lord.
Improve. So we are giving you a free hand. Improve.
What has fallen from my lordships, my lords, I'll also communicate to the investigating officer.
This is
So my brother has now clarified the situation. At least there's something which seems to be amiss.
May I say out of box mirrors?
Yes.
This is the beauty of this court mirror. Now we do 4, 5. Your lordships are so pleasant and
Ah.
very jubilant.
It's because of you. Our is a reflected reaction of the bar. So it is your reaction which sees a mirror in us. Thank you, Mr. Nagmuthu. You have a lot of work to do on the next date in this case. Yes. Good. Huh? Exactly. Yes. We fix the date.
But this will be 3 weeks.
3 weeks.
Yes, ma'am.
Give a date after 3 weeks. Are we sitting in a combination? So this is a tied up matter.
Why is
This is a tied up matter, no?
yesterday?
A special bench ka matter hai, na?
No, my lord.
This is the regular way.
It's the regular.
Regular. We keep it as a part-heard matter on 3 weeks के बाद give a date, free date, 2 p.m. Huh? 1st September. 1st September.
My lords,
1st September.
whatever is convenient.
20 days you get. 21. 30. Oh, 30.
They will come out after time.
No. 3 weeks. Full 3 weeks. 3 weeks, 1 day. ठीक है ना? First go. This will be, that is 2 p.m. This will be 2:30 p.m. First, 2:30 p.m.
Ultimately, it is a
obliged.
civil dispute. my lord. Ultimately, the Honorable High Court said it is a civil dispute.
Mr. Nagmuthu,
My lords.
I think your client should agree. I know you should suggest clear it before the next time. That is after 4 advice. Yes.
Much obliged, my lords.
Yes. No, not 40. One we had passed over. Yes.
My lords,
31, yes.
I've taken an instruction.
Yes.
We have this given the settlement amount in cash.
In cash. Leave it there.
Yes.
Paid to the respondents in cash, which is admitted in their affidavit. The same order work kar diya na, and modified to the extent of the upholding the conviction, only modifying the sentence. Yes.
I'm deeply grateful, your lordships.
Any party present in, I hope there is nobody. But two parties are present.
Matter, my lord, settlement agreement is filed, party is present.
Parties are present. We'll take it. Yeah, call for it. When parties are present, we'll take it up.
I appear for the respondent wife, she
Yes.
is present here.
Yes, who's for the respondent wife, then why are you standing in the petitioner's court? Yes.
Settlement agreement has been filed, my lord, it's on record.
Yes, petitioner.
Yeah, yes, your lordship.
Where is your client?
My client is here. my lord.
No. Where is your client? All the terms complied with?
All terms complied with.
42.
Lord, I am informed he's
He's on
appearing on
VC,
VC, my lord.
He's on VC.
Oh, yes, yes, sorry, two. Yes, yes, yes. Put him on the big screen.
All the terms have been complied.
What are the terms?
Yes, my lord. First, is, my lord, she was to receive an amount of 45 lakhs, which she has received in total.
45 lakhs मिल गया आपको? Yes, और क्या? What
Then,
is
my
there?
lord, she was to receive the Fortuner car, which she has also received.
And
She has been given possession of her property, my lord, which she had received as a gift. It's been mutated now.
gift from the husband. Gift from whom?
Husbands, my lord.
Yes.
My lord, and they have to now withdraw the cases, my lord, against each other.
Where are the cases?
There, my lord, page 5, my lord, para D.
Oh, eight cases. Ugh.
Yes. Where's the application? My lord, page 5 of the application.
Yes, yes, yes. Oh, you have mentioned 8 cases, but you
Yes.
want quashing only of 4.
My lord, para E, my lord, the petitioner husband has filed the cases.
And para D is what you have filed.
The wife has.
Oh, so we'll say that all cases stand
Yes, my
closed.
lord.
Stand closed. Between the parties stand closed. Yes.
No, that's all.
Everything finally done?
Yes.
Yes. Mr. Petitioner, you paid every money, all the money?
Yes, sir. Good afternoon, sir. Yes, sir. Paid, sir. All conditions fulfilled, sir.
You only paid 45 lakhs and the Fortuner. What about the petrol for the Fortuner? She lied on water. Should we close?
Yes.
Then you want mutual divorce also?
Yes.
Where is the prayer made?
Yes, my lord, in the application.
Page number 9.
Page 9, my lord.
It is held on counsel for the party. The party is a paragraph. The petitioner has joined the proceedings through virtual mode, identified by his counsel, and the respondent
2, wife.
number 2. And who are 3 and 4?
My lord, he's actually respondent number 3, the husband. Originally in the SLP, the case was filed by the uncle.
The P1, who is P1?
P1 is, my lord, the uncle
Uncle of the
of the
respondent.
husband,
The relatives of the husband.
because the FIR was had named him. My lord.
No, but she has been made a party.
She's a party, my lord, respondent number 2,
2. Okay.
and husband is respondent number 3.
Respondent number.
That the settlement agreement also records, my lord.
Husband is also on the respondent side.
Yes, my lord. He was only a pro forma party.
Heard on counsel for the. Then where is your client? Your clients are not.
The dispute between the wife and the husband has been settled. Actually, we were involved in the FIR without any proper.
You have learned counsel for the party. The matter basically relates to a paragraph, leave granted, paragraph. The matter basically relates to a matrimonial dispute between the wife, who is respondent number
2, my lord.
2, and her husband, respondent number 3,
3.
who is also related to the petitioners.
Yes.
Full stop. Paragraph. In mediation, the settlement was arrived.
In
or-
mediation before the mediation.
The matter was earlier referred to mediation and a settlement has been arrived. Full stop. The same has been brought on record by way of it's a joint application.
Joint application.
Joint application filed by the parties. Full stop. The respondents number 2 and 3 are two is present physically, whereas respondent number 3 has joined the proceeding through virtual mode, duly identified by their counsel. Full stop. Paragraph. The settlement, terms of the settlement are reproduced herein under. Reproduce the whole thing. Paragraph. From the same, it transpires that whatever money and articles the wife was to receive, the respondent number 2 was to receive from respondent number 3 has already been transferred, which is admitted before us. Full stop. Further, the parties have agreed that all inter se litigations between them be closed, and also a prayer is made for granting them a decree of divorce by mutual consent by invoking a power under Article 142 of the Constitution of India. Paragraph. Having considered the matter in its entirety, comma, we allow the prayer. Full stop. Paragraph. Accordingly, comma, all the cases mentioned.
नमस्कार दोस्तों,
At
माननीय
paragraph.
सुप्रीम कोर्ट में आज कई बड़े और महत्वपूर्ण केस लिस्टेड हुए और उन सभी की मुख्य लाइव हियरिंग के अपडेट्स हम सीधे आपके लिए लेकर आए हैं। यह वीडियो केवल और केवल शैक्षणिक उद्देश्य के लिए है। हमारा मकसद किसी को भी कानूनी सलाह देना नहीं, बल्कि देश के कानून और कोर्ट की कार्यवाही के प्रति जागरूकता फैलाना है। आइए अब देर ना करते हुए आज की मुख्य कोर्ट हियरिंग समझते हैं।
That information, in fact, has not been placed on record. In fact, by way of my lord's order of April 2025, that was a specific query that was put to the High Courts. That at least identify the time that is being
You
taken.
do this also.
Mine.
This exercise.
Mine.
That what is the trend of commercial litigation, growing trend of the commercial litigation in different states, and keeping that estimated requirement in mind, how many courts in a phased manner are required to be issued?
My lords, we
Because with one direction, establishment of entire courts may not be feasible. It all depends upon infrastructure, availability of officers. But this is a process which should be taken care in continuous basis.
Well.
So prepare that
We'll
based on that data, and also indicate that in which state, how many courts are right now immediately required to be. After all, we cannot afford to have a long areas also in these courts.
Well.
So maybe in some of these states, some immediate direction will be required that they need to establish. So we will largely rely upon what the data and the facts and figure you will give.
My lords, we'll place that on.
These states are also party here.
We'll place that.
States and High Court both are parties.
In fact, my lords, earlier directions had been issued to the High Courts only to respond instead of.
Please.
I think the states should also be included because
My
when the
states are
process of
included.
establishment of courts will come.
Yes, my lord, that's.
Mr. Datar, don't you think that states should also be called upon?
Yes, Lord,
My
absolutely.
lord, states are party.
Lord, what's happened is.
High Courts.
But
Yes,
probably notices has not
Notice
gone
only to High
states
Court.
so far.
Please, Lord.
The whole idea of commercial court is to expedite the hearing, but if that is not going to be answered, because that the whole thing, a part of ease of doing business is how far a commercial decision is decided by the courts. That was the very logic in which we started commercial courts as a departure from the ordinary civil courts. So a lot of changes were made. Yes. What should we call it after 2 weeks?
The High Court will also depend upon their states for establishment of additional courts wherever it
Yes,
will be
yes,
required.
yes.
So by the time that this information is collated and if the case for issuing direction for establishment of additional courts is made out,
Yes.
then better the states are also present
Yes,
so that we
yes.
can direct them.
And Lordship is right, it will vary from state to state. Necessarily will vary from state to state.
In some of these states where you have more cosmopolitan or urban major cities, there the commercial litigation might be
Higher.
growing with a fast speed as compared to other states were dominated by rural areas.
Yes. Yes.
Going by the definition, comprehensive definition of commercial disputes, I think that might be the trend of the litigation.
Absolutely, my lord. Lordship is right. Lordship may call it after 2 weeks, my lord. We'll just see what the progress is.
We can issue notice to the state meanwhile
Yes.
and
Let
say, once what the petitioner has placed on record, the relevant information in a detailed, in a tabulated form, depicting the number of pending commercial cases as on 31st January 2025 and the corresponding infrastructure that has been provided for the commercial courts. It seems to us that the information needs to be updated at least as on 31st January 2026.
My lords, the information is not as of 31 January 26. It's of 2025, 31/3/2025.
Needs
Because-
to be updated.
Yes.
We are saying that needs to be updated.
Needs to-
Needs
My
to be
apologies.
updated as on 31st January 2026. Along with details of the additional, along with the details of the infrastructure that has been provided so far. We have also impressed upon the counsel for the petitioner to collect the data with respect to the growing trend of commercial litigation statewide and to have an estimated requirement of increased commercial courts, a requirement of additional commercial courts in such states, that information may necessitate to issue appropriate directions for establishment of additional commercial courts. Next paragraph. In this regard, for the purpose of establishment of additional commercial courts contemplated as contemplated above, the presence of the state governments is also the presence of the states governments is also it is necessary to ensure the presence of the state governments. Let therefore notice be issued to all the states who are already included as party respondents, returnable on so and so date. These states may be served to the standing counsel in the Supreme Court or to their respective advocate. Post this matter for further consideration on so and so dates.
Lord, with your lordship's kind permission, can we they prepared a very detailed compliance chart with granular detail. Can we send this also to the high court so high courts can respond? Lord?
Yes,
Very
yes,
granular
The
table is given. Either we can give high court wise or we can give the
information collected by the learned counsel for the petitioner in the tabulated form is taken on record.
High courts are represented.
Yes. Do you have a soft copy of
My lords, I do. I will file it.
that? Be soft copy for of the registry.
Yes.
The registry directed to send a soft copy of the information of the information in tabulated form to all the high courts, seeking their response on the date fixed, before the date fixed.
deep level.
Much.
Thank you, Sir Datta.
My lord, pleadings are complete in this matter. It will require some time. May I request for a non-miscellaneous?
I appear for the High Court, my lord.
In some fixed date, my lord. Obliged.
May I please.
Lordship, may I submit in item 37?
Yes.
Yes, Lordship, the only point of difficulty in item 37 as of today it stands is the Common Law Admission Test Consortium of NLUs have issued the application form and the notification for next CLAT cycle on 22nd July. But they have neither issued the revised instructions for persons with disabilities, nor in the application form, the ability to give exams on computer is incorporated. It only asks you to fill the details of the, to select the mode of giving exams through scribe. So those are the only two directions that we are seeking through my lords. That one, they should be directed to issue the instructions along with the application, which has now commenced on 3rd of August. So now, since that deadline is passed, obviously they may be directed to do so in a week or two, as my lords deems fit. And second is that they should be directed to include in the application form itself that the persons with disabilities would have mode of giving exam using screen readers, which is currently not captured.
We usually give that notification for PWD candidates. I appear for the consortium, Lords. We usually give our notification for PWD candidates about 2 or 3 weeks after the main exam notification is issued. It is in the process of being finalized. It will be issued in the coming week or next 2 weeks. The exam itself is in the month of December, so there's sufficient time. Last year also we filed a compliance affidavit.
Should not invite any direction from us. You yourself should voluntarily do it.
Yes, it's being done, my lords, and in fact, last year also pursuant.
Suggestion which Mr. Jain has given today.
Yes, my lord.
Take note and make sure that
We'll do it, my lords. There's no difficulty. Last year also, all candidates who wanted scribes, either personal scribes or from the pool organized by the examination body, they were made available. Plus, those who wanted screen reader software, that was made available.
standard procedure.
Lordship,
There is a procedure, my lords. Every year they update that. The EC meeting has to happen, my lords, because the draft is put up for the.
Make it part of your instructions.
It'll be done, my lords. It'll be done. No difficulty.
Lordship, my only
I'm
submission
appearing
on
for
this is
the
that
Department of Empowerment of Persons with Disabilities. We had a comprehensive revised guidelines on 1st of August 2025. However, that is on hold further now because there is a wider stakeholders consultation which is going on, my lords. So, my lords, we will come up after a revised guidelines will come up after that consultation is complete, my lords.
And in fact,
Lordship,
that
irrespective of yes, Lordship, irrespective of those guidelines, the 2018 guidelines itself contemplate issuance, the giving exams through assistive technology. So that guidelines really would not have much bearing on this issue.
That's not there.
If they update the guidelines, it is always better.
Yes.
Those guidelines are for the competitive examinations as a whole, my lords.
Yes,
That
Lordship.
exam guidelines will be now issued.
Yes.
Court's direction.
Yes.
They're also anxious. You should let them know in earliest.
Lordship, it should be made part of the application form is my submission, as in when they release the notification for the application is my submission.
Whatever issues have been raised on behalf of the petitioner will be effectively addressed. It will be effectively addressed for the next examination that is likely to be held in December 2026. Let a comprehensive SOP, stroke instruction, examination instructions be issued by the consortium in this regard, and a set thereof be placed on the report for our consideration. Next paragraph. The way Additional Solicitor of India, representing Women of India, Ministry of
The Department of Empowerment of Persons with Disabilities. Respondent number 1.
Persons with Disability states that press guidelines, comprehensive guidelines are in the process of being finalized.
Yes.
For which suggestions from different stakeholders have been invited.
Are being considered.
So let that process be completed at the earliest. Post the matter for further consideration. This within September and Mr. Counsel, you make sure by September and everything.
We'll do that, Melody.
For consultation, we have given an outer limit till 31st of December 26, or earlier. If those are complete, we'll come out before that as well. I'm grateful.
Lordship, anyways, those guidelines deal with public competitive examinations. Here we are on postgraduate examination for common law admission test. So those guidelines are different.
Those are comprehensive guidelines for the competitive exam as a whole. There'll be certain guidelines which will also be helpful if, my lords, a wider guidelines say that scribe can be used, or there's a particular way that it has to be done, that can also be taken up by the
No, I'm not saying in an adversarial manner. I'm not saying in an adversarial manner, ma'am. Only I'm submitting is that those guidelines relate to public examinations, whereas of competitive nature such as UPSC, etc., which are for recruitment. This is pursuant to the Prevention of Unfair Means Recruitment Act, basically. But these guidelines are already sufficient enough to cover educational institutions such as consortium of NLUs. So
let us see that guideline.
yes, yes, Lordship.
I'm
Yes,
grateful.
Lordship. Grateful, Lordship.
Item 39, there is a letter circulating. 38 and 39, yes, the board.
Please, Lord. This is a Section 11 petition. None appears despite service. They are contesting in the Section 9 before the High Court. The agreement cannot be disputed. The defenses which they are raising, my Lord, are purely within the domain of the arbitration tribunal. Because now your Lordship is aware only the existence has to be seen. So my prayer is, my Lord, that the arbitrator may be appointed, and whatever defense they have as to whether they are the successor of R1 or whether they have purchased these assets encumbrance free can be decided by the arbitrator.
The assets of R1?
That's their case. According to us, they are the successor entity of R1. According to them, they have only taken over the assets free of encumbrance. Now, these are disputed questions of fact which will lie within the domain of the arbitrator. And next year,
Time they are appearing in the High Court.
yes, respondent number 9 is appearing, my Lord. Please have page 422. That is the reply filed by current respondent 2 before the High Court. So they are aware of these proceedings. Their stand is like akin to SARFACI.
Number 2, unfortunately, you not served.
Oh, I'm so sorry, my Lord. My Lord, can I be permitted to serve them in the ongoing proceedings in the High Court?
To the local council.
Yes, my Lord. We'll do that.
As per the office report, service on this committee is incomplete. Let the said respondent resolve to the council representing the said respondent before the High Court. Recommendable on council.
My only request is, since it's an 11, if your Lordship would be pleased to have it at a short, convenient date, I would be obliged. The agreement is admitted. Obliged. Lordship, please.
This matter has been settled, 41. MA number 181543 has already been filed, in fact, by the petitioner.
Well, I appear for the petitioners in the matter. Matter has been settled.
The Arbitration Council is on VC.
And at page number 12.
Well, the matter has been settled. I appear for the petitioners. Matter has been settled. My lords may be dismissed as withdrawn in terms of the settlement.
Jointly state that the dispute has been amicably settled. And just the president arbitration to dismiss every withdrawn. Order recorded.
Grateful for the nudge that came from the Honorable Court that resulted in the settlement.
My lords, in terms of the settlement agreement, if my lords can be recorded that one line.
I'm saying that the parties shall abide by the terms and conditions.
Deeply grateful, my lords. Deeply grateful.
Obliged.
Item 42.
Please, my lord. I appear for the petitioner, my lord. Respondent number 1 has filed a short reply. In paragraph number 4 of that reply, my lord, they say that there is I filed a composite petition. However, my lord, when they respond to my petition in the High Court, at page 241 in paragraph number 4, the same respondent says it's an international commercial arbitration.
Who's for the respondent?
So is item 42.
Lord, I appear for the petition. Mr. Vishal Arun Mishra has filed the response for respondent number 1.
So again, I think
Number
respondent
2 is unserved. Respondent number 2 has not been served, but there is a reply from respondent number 1.
Yes, ma'am.
As per the office report, service on this number 2 is incomplete. Then claim order procure may be served.
Lord, in 45, there are 3 IAs. 1 by us, we are the original petitioners, and 2 by people who are frustrating the High Court from hearing the matter. Just see the last order which the High Court has passed in our IA, my lord. The IA by GWA. If your lordship will see that IA,
my lord, the IAM
the order is at
appearing in the
366.
relief, my lord, it can't be granted in this case.
No, my IA is also there.
On multiple occasions.
We are also the applicants.
Just see that order which you are, which.
Still pending before Justice Bambani.
Yes, the whole idea is to somehow ensure that he doesn't hear it.
If my lords may
Day after day, my lord, dates are being taken that we are going to Supreme Court. And Supreme Court is going to further clarify something, and that is why they are not permitting that hearing to go on. And they are repeatedly coming here only to frustrate that hearing. Only the whole purpose is to just see his last order, my lord.
I have one additional point I want to make, my lords. This is a blatant attempt to interfere with Justice Narasimha's proceeding, where he has reserved orders on an appeal as to whether the CIRP order, admission order, should be recalled on grounds of fraud. In order to get some observation from your lordships that they can then place there, they haven't filed written submissions as required within 1 week by his lordship's order, by his lordship Justice Narasimha's order. So, my lords, I represent a home buyer, my lords. There are 1,091 of us. My lord, the Chief Justice, has been very vehement about, my lords, protecting the rights of cheated home buyers. We've been cheated twice. First,
Lordship, I am for the IRP. Now by the
which went into insolvency. My lords, 1 minute, my lords.
But this was
Went into insolvency, which led to this. The allegation by ED is that they've siphoned off money. Now, my lords, Oris was the landowner who signed all the documents, took 196 crores, and now they are trying to deprive us of our flat.
This was
90% of the first phase was constructed. They've taken orders, my lords, from the High Court saying that all flats to be given only to Oris buyers.
I am for the IRP, lordship.
Where your lordship should order a CBI investigation.
Well, this was only listed for appointing monitoring authority as per the direction of this court.
Oris has also been declared to be a financial creditor.
Can I support them?
The builder is declared to be a financial creditor.
I need to proceed. We are for the applicants just because.
Can I support the applicant? Can I support the petitioner that side? Just 1 minute. Then the respondents can argue. I am a supporting person to supporting to Mr. Vikas Singh Krishna Venugopal for this reason. I'll take only 2 minutes. Please see the impugned order. My lords, the Honorable Supreme Court passed an order of 10th of April to 2026 at page 33, relevant malus at page 34. There was a clear intent of my lords that it will go back to the High Court and they will determine who are the home buyers who fall into this category, and then further proceedings will be taken. Now, malus, the impugned order, which so-called impugned, which my learned friends on this side are challenging. Once, let me finish, please. Yes. Is a cry of anguish by the learned High Court judge. Just see 2 paras of that. What they have done, my learned friends, both sides of it. No, but that's absolutely wrong.
Allow
me to finish.
Please allow me to finish.
Allow me to finish.
This is not a question of finishing. You are on a wrong.
I don't understand this. I'm in the middle of a sentence. By out-shouting, you can't hide the truth. I'm reading what is written. Please turn to para 2, page 316. Page 316 of, yes. Para 5 onwards. The prayer in the miscellaneous application filed there is to
Page number?
give the page number.
This is in our IA, Lord. GWAIA.
Allow me to finish.
47940.
Chief Justice has told you, allow me to finish. 317 of Mr. Vikas Singh's IA. GWA. Give the IA number, please. This is not the way the High Court is to be short-circuited after my Lord's mandate.
Well, that's misreading of the application.
Let's read now.
Yes, go ahead.
Page 317, relevant part. Yes. Relevant part only.
The order of 3rd August you are.
That's correct. That's correct. I'll just read without
just read my own words. The 4th August order, which I wanted to show.
The prayer in the miscellaneous application filed before the Supreme Court, a copy of which is appended, reads as under. They give the wrong application to the High Court judge. They give the wrong application to the High Court judge. Defer further adjudication of the present matter as an application seeking clarification of the order of 10th of April, that is my Lord's order, presently pending. 6. Evidently, the prayer extracted above is erroneous, considering it has been made before the Supreme Court of the miscellaneous application as per the copy of the miscellaneous application appended. Then, regardless of the prayer, Mr. Mathur submitted to the court may note the fact that the applicant has passed the said miscellaneous application and may pass appropriate orders. Learned counsel, read 8, para 8. Learned counsel appearing for other parties, including GWA, that is Mr. Vikas Singh, and the Directorate of Enforcement vociferously opposed the prayer, submitting that quite apart from the fact that the prayer in the copy of the miscellaneous application makes no sense. It's a wrong application filed. Nevertheless, the filing of the application for the Supreme Court is intended to only stall a further proceeding, which is undesirable. Upon this being pointed out, Mr. Mathur, who is for the side who filed the wrong application, gives the correct application, which is today listed. My Lord has got this para 9 application listed today. This is the current
Querying for that.
correct,
I'll
correct
clarify
one.
this position, Mr. Singh.
The different copy of the miscellaneous application is taken on record. Now come to 11. Clearly, the prayer in the application filed before the Supreme Court is to seek a direction that this court may not only defer restitution or disbursement of the proceeds of assets and appoint a former judge of the Supreme Court as monitoring authority. On the other hand, in the present application, prayer is to defer further adjudication. On a combined reading of the prayers in the present application, the miscellaneous application, this court is unable to decipher exactly what the applicant, that is people on my side as well as Kusum Dwivedi. It may be recorded that this bench was in sizen of the present batch of matters. He has had 14 hearings, the learned judge, and is about to decide this matter of who the home buyer after 14 hearings. Under Supreme Court directions, upon change of roster, it is placed back before him. Ignore that. Come to 14. Counsel for ED, GW and other parties have expressed their unreserved stand that this bench must continue hearing the matters. Everybody, except Ms. Kusum Dwivedi and 1 or 2 others. Mr. Kunal Tandon, learned counsel for the promoters of 3C, also states that they want the matters to proceed. As a matter of fact, at the conclusion of today's hearing, Mr. Tanmay Mehta, learned counsel appearing for GWC, that is Mr. Mehta is opposing Mr. Vikas Singh, also says that they are desirous that the matter be heard before this bench. In these circumstances, Mr. Mathur, learned senior counsel, appearing for the applicant, seeks time to take clear and categorical instruction. Now turn
And the next order.
Next order.
Next order is very important.
Right next, immediately after this, come to page...
Starts at 325.
325.
325. Fourth.
Yes,
Fourth.
that's the next one. At yesterday's hearing in the present batch of matters, Mr. Counsel appearing clear instructions. Leave that one. Come to para 3. By way of the present application, Kusum Dwivedi says, defer further adjudication. This is a kind of a game going on, Malus.
It's absolutely...
No, please see after.
Absolutely wrong. Kindly see...
Para 4. The moment
kindly see the application which is already on record.
Please don't interrupt me.
Kindly
see.
Para 8.
Para 4. Before attempting to understand that the applicant wants by way of prayers, it must be observed that a copy of the miscellaneous application was appended. Then, subsequently, learned counsel informed the court that the copy so appended is not a true copy, etc. Leave this.
Go to para 8.
This was on the same
Now
day.
come to para 8. Para 8. Para 8 is most important. This court is constrained to observe in the course of hearings over the last several dates. This court has got the clear sense that there are divergent vested interests at play in the present matters. After my Lord's order, some of whom appear to be interested in derailing or prolonging any effective orders being passed in the present case. Accordingly, this court would view the present with requisite caution. Considering the evidently contradictory pleas taken in the present application, the application filed before the Supreme Court, before proceeding further with the matter, the applicant Kusum Dwivedi is directed to file an affidavit clearly stating her locus standi.
And then 11.
She pops up as one home buyer.
I am appearing for...
Let the
lead. I must make given a chance to clarify.
After I finish.
Please give me...
Furthermore, it is observed that as recorded in the order of 30th July, Mr. Aman Lekhi was to continue with his submissions. However, Mr. Lekhi was not present on 3rd, nor is he present today, nor is any other counsel present on behalf of COC. Now, how does a judge carry out the mandate of finishing if I don't go and argue?
And your lordship is being given in their IA, it is given as if he is not hearing the matter.
On my application,
please change the
Mr.
judge.
Sikri had made that statement. On my application as a home buyer to say that, kindly allow me to clarify this position. If my lord sees by April's orders of my lord, the ED as well as the special court PMLA said that using the provision of section 8 of PMLA, the attached assets of the promoters are to be disbursed to satisfy the claim of the home buyers, which I am one of the home buyers. Court said that please, initially the judge was appointed and thereafter was withdrawn. Later on, this in the application came, my lords, of the order of 10/4/2026 noted that the ED also said, and we also said, please appoint the monitoring authority, some judge of this honorable court, my lords. We said, my lord said that the High Court consider and decide them that. That's the order on page para 8 which has been done. This is the application I filed. This is the position I have taken before the court that since the assets are there, ED has confirmed this position. Special court has agreed with that position. Please appoint the monitoring authority. The challenge every time from them is on a one pretext or the other that these assets should not be dealt with. All today I'm making an application with instruction, my statement may be recorded that any monitoring authority may be appointed to deal with it.
Lord, may I just point out?
Today, one application or the other, my lords can see that there is a bloodbath going on the all sides.
They are filing the application.
Nobody is going to get any asset.
Not letting the hearing go on.
Averse to appointment of any monitoring committee, but let such a decision be taken by the.
Can I
look at the situation before my lords. Look at the situation, my lords. There's a competing interests which are there. There's may vested or not vested. I'm not casting any aspersion against them. Any authority who can look into it, all I'm saying, because this exercise it takes 9 hearing it takes this authority 9 hearing it takes that today we can't reach a point. Somebody can
please see all the hearing dates. Every date they have delayed.
They want nobody else should speak. Nobody else should speak, and they should get and prejudice the court on one aspect or the other. All I'm praying before this honorable court, any authority may be appointed that's going to assist the court, so that the claims can be examined.
Mr. Bulbir, let the court take a call on it. Require the assistance of a monitoring committee, the court will constitute that committee. If the court requires assistance of some other domain expert, the court will.
Absolutely. With so many
people should.
Can I just? I am for the other applicant.
Your lordship can say day-to-day hearing, Lord. We are ready to.
All the parties on 24 consented. We consented on this aspect, all of us at that point. When this order was.
Can I please be heard before them? My turn. I am for the applicant. Lord, Mr. Singh and Mr. Venugopal won't allow us to argue. Lord, my submission is very simple.
May I submit on behalf of
Lord, my point is this.
Yes, is also there for ED.
Lord, today the point is this, that certain assets of the defaulting promoters who admittedly siphoned off the money have been seized by the enforcement director. Who that money has to come back to is a different question which is under adjudication. Why should those assets not be monetized in a pool for all home buyers? Mr. Singh's client, Mr. Venugopal's client have been obstructing the appointment of...
No, there is no obstructing at all.
Absolutely not fair.
I think the ED will answer this question better.
Let that money
I think Mr. Raju will answer this question better. Whether
there's a dispute.
No, we want to. We want to.
My lord, I have not been.
We are compelled to file the application only to bring the subsequent orders on record.
I'll explain why.
Yes.
I'll explain why. My lord, every time the matter comes up before the High Court, after your lordship's order is shown and the ED suggestion is made, Mr. Singh's and Mr. Venugopal's clients say we are opposing this for the...
No, never. Just read the order.
Precisely, that's the...
Just allow me, my lord. They are opposing restitution.
If they are opposing, ultimately for the just to take a call.
Decide.
Lord, that's not... Just let me explain. My lord, what they are opposing...
They will eventually...
If you come here with an SLP, how will the case get over? It's listed on 13th August. Go and argue on your case. All your problems will be sorted.
Our trepidation is that they are not allowing the hearing to conclude one way or the other.
Court not control. This is also it's a High Court.
Lord, I agree, but our trepidation is why should money siphoned off?
File an application because somebody moved an application.
No, they are only moving application. Lord, they are only moving application. They are seeking adjournment and now coming here and saying that the matter is not going on. Just read the entire order sheet. I can read all entire order.
Problem if cheated money is put in a pool under the supervision of...
That's precisely the point.
We have no difficulty with that, but that is only a purpose to derail that proceeding.
That cannot start the proceeding.
I have a suggestion.
I think Mr. Raju can answer that point. ED proceedings are... Mr. Raju is also having a problem with the judge's order. They have also challenged that order.
May I only
permitted to argue.
In this in the High Court.
Learned senior. I have a suggestion.
Mr. Raju's voice is...
Am I audible, my lords?
Mr. Sadhu, do you want to say something additional?
Yes, my lord. I want to say this, my lords. First, my lord, direction should be given to the learned judge in the High Court to decide the matter as soon as possible, preferably within a time-bound manner. If 1 week or so. One. Secondly, my lord, as far as ED is concerned, ED is not concerned with the properties of the company. This is a property of the promoter, which is outside the purview of the resolution professional. I don't want the IRP to intervene, my lord. I have doubts about the integrity.
I am here.
I'm here. To monitor the entire thing, including adjudicating who are the genuine home buyers. If the IRP steps in, it is going to be a chaos, and it is unwarranted persons and persons who don't deserve will be given the money which I don't want. I want a retired judge of this honorable court to monitor who are the genuine home buyers.
Genuine
Because
home buyers, only that question.
a large number of home buyers are propped up by the builder, my lords, which I don't want.
Whom they are
That's
representing.
And if identification is a problem, therefore a retired judge of this honorable court must decide who is to get the money.
The home buyer.
They are not allowing the high court to proceed, my lord. Every day there's a ruckus in the court.
May just bear with me for a minute because Mr. Raju has raised a point on the IRP. I just need to 1 minute. No, let me address the court, please. Lordship, it's as follows. This IRP, for whom I'm standing, was appointed by an order of the NCLT, and the direction was verify the claims. The problem with this particular case is that it was a collusive proceeding started CIRP by the ex-promoters who took the money, siphoned it off, and then disappeared. And then somebody propped up and immediately admitted the claim. At that point, there were 2 IRPs changed. This is the third one. The third one came, he was directed, please do a verification of claims. 3 reports were submitted. That challenge to the verification was rejected by the NCLAT.
No.
1 minute. I am addressing the court. This is not fair. I am addressing. No, I will. Lordship, I am not saying anything incorrect. I'm sorry, Lordship. I will not say anything incorrect. I owe it to the court. I don't owe it to any of the claims.
No, you are being dishonest.
No, I'm sorry. I'm not dishonest, Mr. Singh, and this is not fair.
He should act.
This is no. The challenge to the verification is an order of the NCLAT which clearly rejects it. Now, there are 2 home buyers here. There is a GWA, which is an association, Greener-Polis Welfare Association. There is a GWC, which is a Greener-Polis Welfare Confederation. Now, in between, just bear this in mind, these 2 are fighting with each other. To cut a long story short, there are 3 status reports, including the verification, with no cooperation from the ex-promoters. Whatever was there was placed before the court. Now, thereafter, the matter came before this honorable court. This honorable court, in continuation of the CIRP proceedings, directed the NCLT to look at the complaints on the IRP. That also has been adjudicated.
No.
Yes, it has been. There is an order. Lordship, it's an order of December 2024. I'm sorry, Mr. Singh is not instructed. Note of the ED, which says, just last 3 sentences, press note of the ED comes out for restitution of assets. The IRP is before this court says, yes, I'm giving my undertaking as per the press note that the restitution should be done. The issue is restitution. The challenge here is that when the IRP files for restitution, one set of home buyers files a contempt against me. When he doesn't move on restitution, the other set of home buyers do it. These are competing interests. The court has to decide. Lordship said for a judge, perhaps that's the best way.
Because this IRP is in contempt, there's a judicial order saying that he's biased.
He's colluding with the builder.
He's colluding with the builder.
And the NCLT has found, my lord, the NCLT has found that he is colluding with the builder. He's made the builder, my lord, as a COC member. Builder, 80%. 80% is honest according to him. And he's trying to defend the home buyers. He says, and all the home buyers, not the genuine home buyers of 13, have been rejected by the IRP.
Notices have been issued against him.
That ED's prayer
It's correct, Lord. It's correct, yes. That should be done.
That's
Let
the
home
Once
buyers come and buy a retired
GWA is a front of the
who is
promoters.
the genuine home buyer, let it be decided by a Supreme Court judge. We have no difficulty.
Well, that's all we are saying. Not everybody. What ED is saying.
Just one request. Direct Justice Bambani or request Justice Bambani to hear this matter day to day at 3:30 p.m. and finish the entire batch, my lords. That's our request.
That will be best, yes. Even
That's what I said.
And in the meantime, these claims can be verified by the.
These applications have been moved for clarification stroke modification of our order dated 10th April 2026. By that order, we decline to express any opinion on merits of the allegations or cross allegations made by 2 sets of home buyers and thought it appropriate to request the learned judge of the High Court to take up the case for final disposal. The parties were directed to extend full cooperation to the learned judge. Next, right, we mentioned that the matter was pending with Justice Anup Jairam Bambani of the Delhi High Court. Various orders passed by the learned judge revealed that despite his efforts being, and despite his despite the
Honest efforts
extraneous
made by-
despite the best efforts made by him for early disposal of the case, comma, moving of one or the other application by the contesting parties is creating impediment before the learned judge. First, in such circumstances, comma, we are constrained to issue additional directions in the particular circumstances, comma, while disposing of these applications, comma, we are constrained to issue the following additional directions. 1I, we request Justice Anup Jairam Bambani to continue with the matter on day-to-day basis and make an endeavor to decide it finally at the earliest. 2, senior counsel, counsel for the parties are requested to extend full cooperation to the learned judge towards final disposal of the matter. 3, the Justice Anup Jairam Bambani will continue with the matter even if there is a change in the roster. Even if there is a change in roster. Next paragraph. The High Court may consider the prayer made by the Enforcement Directorate of Enforcement and other competing parties, reconstitution of a committee headed by a former judge of this court, and an appropriate decision in this regard may be taken.
To monitor. No, Lord. With regard to restitution.
For restitution.
Not the scope.
No.
For
Left open.
for monetization.
The court will decide, Lordship. The court will decide.
They don't want the assets of the promoters to be liquidated.
This is
But they are actually fronts for the promoters.
Very well. That is.
Yes.
That will be sufficient.
My lords may say preferably within a week, but let dispose of the petitions.
No further application by the parties to delay the ongoing proceedings. before the
Very
court.
deeply obliged.
Most deeply obliged.
Grateful, Lordship.
Extremely grateful.
Lawyer unfriendly thing was. Been 25 applications last 2 weeks. A lot of lawyers will be very unhappy.
There are 2 more hearings which have taken place.
No. I would not only beseech.
It's a common cause prayer made by Mr. Singhvi.
Lord, I would.
I'm not making a prayer.
Lordship.
Would your lordships only one small request, Lord? Could your lordship say identification of home buyer as well as restitution? I'm not difficult.
That's absolutely correct.
Lordship, let the
That has
court
already been
decide.
done.
Let the court decide.
Will be decided.
Very well.
Yes,
Let the
Very
court
well.
decide.
Very well.
Let the court decide.
Deeply obliged. Deeply obliged.
Deeply obliged.
I think in the interest of all of you, if matter is decided earlier.
Not in their interest, Lord. Not in their interest.
Lord, they are actually fronts for the promoters. They are obstructing.
On the contrary, my lord.
Ones who want the restitution for the promoters money to come.
Grateful, Lord. Deeply obliged.
That is what Justice Bambani will decide. Who are the
Grateful, Lordship.
deeply obliged.
नमस्कार दोस्तों, माननीय सुप्रीम कोर्ट में आज कई बड़े और महत्वपूर्ण केस लिस्टेड हुए और उन सभी की मुख्य लाइव हियरिंग के अपडेट्स हम सीधे आपके लिए लेकर आए हैं। यह वीडियो केवल और केवल शैक्षणिक उद्देश्य के लिए है। हमारा मकसद किसी को भी कानूनी सलाह देना नहीं, बल्कि देश के कानून और कोर्ट की कार्यवाही के प्रति जागरूकता फैलाना है। आइए अब देर ना करते हुए आज की मुख्य कोर्ट हियरिंग समझते हैं।
That information in fact has not been placed on record. In fact, by way of my lord's order of April 2025, that was a specific query that was put to the High Courts. That at least